Hi, I'm Sarah Brown and I'm one of the solicitors at the Adoption Legal Centre, also part of Ridley and Hall Solicitors. As part of National Adoption Week this week, we're going to be posting a few articles and a few blogs on various issues that we've been asked to advise our clients on previously, and a lot of inquiries that we get coming through. Now, the first topic that I'm going to be discussing is adoption breakdown or adoption disruption. I know various people call it various different things. Now, at the Adoption Legal Centre, we get quite a lot of inquiries from adoptive parents who are in a situation of crisis. This is normally when they're either having child and parent violence at home, whether that's weekly or on a daily basis, or the child's displaying really challenging behaviours which is just beyond their control. Now, that might be due to diagnoses that the child has had, due to early life trauma that they were subjected to previously prior to being adopted. Or they might be having challenging behaviours at school, running away from the family home. The list is endless. There's no one particular point that we get asked to advise on particularly. Now, when an adoptive parent comes to us saying, well, what are my legal options now? We've been asking for support for months, if not years. We're not getting it, or they are getting it, but it's just not working. The situation's just deteriorating even further. What we do is we advise on what's known as Section 20. So this is where we request on behalf of the adoptive parents that their child is accommodated by the local authority. Now, that can either be in foster care or residential placement. It depends what's available in your area at that time. It also depends upon the needs of your child. Not every child will need residential care, and there's not always a residential placement available. The majority of children are accommodated into a foster placement. Now, as part of advising on Section 20, what we do is we write to the local authority, setting out a background in terms of the child and the family, saying this is what's happened previously, this is what the situation is at home, and this child is really a child in need because of his behaviour, and therefore he needs to be accommodated. What we then do is we then go on to explain to the local authority their duty under Section 20. Now, each local authority should accommodate a child if a child's abandoned, or if a parent is prevented from providing suitable accommodation or care for that child for whatever reason, and that's usually due to the behaviours that they're displaying in the family home or at school. Now, some local authorities will come back to us and say, yes, we agree the child should be accommodated, it's something that we've been looking at, something we've been discussing with the parents, we just need to find a placement, and the situation can go from there, and a child might easily be accommodated then with everybody in agreement. Some local authorities will come back and say, well, we question whether the child is a child in need and whether the child does need accommodating, and at that point that's when we need to start negotiating with the local authority to explain this is what the situation is at home, this is a family in crisis, it can't continue like this for either the family or the child, and therefore this child needs accommodating. Now, for a child to be accommodated, the parents who have parental responsibility need to give their consent. They will do this usually in what's called a Section 20 agreement, where you just ask to sign and date to confirm that you're giving your consent for your child to be in local authority care, and then a social worker or team manager will then probably sign it underneath. You could withdraw your consent at any point. If a few weeks after you've decided that you wanted the child to be accommodated, you think actually he or she might be able to come home, or we're not sure we can continue with this, then you can just say, I withdraw my consent, I want the child back at X time tomorrow, or whatever date. The local authority would then have to return your child. The only way the local authority could be prevented from bringing your child home is if they made an application to court, and that would be to share parental responsibility with you. Now, I'll come on to discuss that later on, because that's known as care proceedings, and sometimes most of the time, Section 20 and care proceedings are linked. Now, if your child is accommodated, the next question that we get asked a lot is, will we still be giving information about the child? Will we still have contact? You always have parental responsibility under Section 20. The local authority don't legally have parental responsibility. As I mentioned, the only way they can share parental responsibility is if they obtain a court order. Now, some local authorities have previously said to adoptive parents, we don't agree with contact, we don't think it's in the child's best interest, but the local authority shouldn't be telling you shouldn't be preventing you from having contact, because as I said, you still have sole parental responsibility for that child. If the local authority want to be in a position where they can tell you what contact you should and shouldn't have, then that's where they need to be sharing parental responsibility with you by way of a court order. Now, we have plenty of clients who have very regular contact on a weekly, fortnightly, if not every few days, whilst a child is Section 20'd. It very much depends upon each family's circumstances. Some teenage children will say that they don't want contact once they're in foster care, and again, there's nothing anybody can do to force them, but everybody, including the local authority, should be encouraging them to have contact with you. But if you're saying you want contact and the child's saying they want contact, then the local authority should be promoting that with you. And if it's an issue that arises, then that's something that we advise on and raise with the local authority. Now, courts at the minute are viewing Section 20 as a temporary measure. So if you're saying the child can't come back to your care before he or she reaches 18, then at that point the local authority should be looking at making an application to court to share parental responsibility with you, and that's what's known as care proceedings. Some local authorities will issue care proceedings not long after a child's accommodated, while some will wait months, if not a year, or if not longer, we've had it previously, to do that. We can't make an application to make the local authority share parental responsibility. That's an application that the local authority have. Now, I know from speaking to my previous clients when they've come to us that care proceedings does get a lot of bad press, and for some I can understand why, but for some families it can really work, and it can be a good thing for them. Some families might have been requesting a psychological assessment or an expert assessment for years or months, and they're just not getting it. And when we're in care proceedings, that's an opportunity for us to be raising that with the court, saying, in order to figure out what the long-term plan is for the child, we need an expert assessment to look at the child's behaviour, to see what that child's specific needs are, and also what support that child needs in future, and what support the child's carers needs in future, whether that's foster carers or whether that's a return home to the adoptive parents. Now, that's something that we can look at if the local authority ever issue care proceedings following a Section 20. Another good point sometimes about care proceedings is that children are given a children's guardian from CAFCAS. They are independent of the court, the local authority and the adoptive parents, and they're there just to look at what's in the child's best interests. And they'll speak to the child, they'll speak to the parents, they'll speak to the local authority to try and get a full picture of what's gone on previously and what needs to happen now in order to get a long-term plan for that child. And it might be a guardian that comes on board and actually looks at the whole situation and thinks, well, there needs to be an expert assessment, and asks the court for one. And that's something we can look at within care proceedings. Even if care proceedings are issued and the local authority look at sharing parental responsibility with you under a care order, you still share parental responsibility with the local authority. We have a lot of clients that think if care proceedings are issued, their parental responsibility is totally gone because that's what they've been told by other people and other professionals. That's not true. Even under a care order, you always have parental responsibility. It's just shared with the local authority. Now, in future, if conflicts arise, then it might mean that you and the local authority have to discuss things, and if the local authority don't necessarily agree, they do have the overriding say. But under Section 20 and a care order, you should always be kept informed of the child, any updates from school, things like that. And you should also be asked to join meetings about the child, as again, whether that's at school meetings or whether it is looked after child review meetings, which will happen if a child is placed in local authority care. Now, if you'd like any more information on Section 20, I've only covered it in basic for now, just to cover some of the points and the many questions that were asked. Those are the main questions in terms of contact, what Section 20 means, your parental responsibility under Section 20, and does care proceedings automatically follow, and if it does, what happens to my parental responsibility at that point. If you would like any further information, or if you do think that you are in a situation where you just can't continue as you are, you're not getting the support that you need, or you just want to know what your options are in future, if you feel that you are getting to a point where you might be in crisis, then please contact us. at the Adoption Legal Centre. If you go on our website, which is www.adoptionlegalcentre.co.uk, there is a number on there to call, or if not, you can call the Ridley and Hall office number, which is 01484 538 421, and you'll be put through to our central services team, who will take your details, and then either myself or Nigel Priestley or Michelle Silcox, we can all advise you on any issues relating to adoption. Adoption breakdown isn't the only area that we're asked to advise on, and there will be some articles this week coming out on adoption support. So if you are in a situation where you are struggling, what you can do, what you need to be asking the local authority, and we'll also be doing some videos on foster carers who might want to adopt and step-parent adoption as well. So if you have any problems, just drop us an email or visit our website or give us a call, and we'll see if we can help you. Thank you.